Welcome back to Canadian Justice, where we're discussing proposed federal cybersecurity legislation, Bill C-26, and the civil liberties concerns around that proposed legislation. Now, Brenda, you have said that in this open letter, that Bill C-26 allows the termination of essential services by secret government order. Can you explain what that means? Like, what types of services could be cut off, and on what basis?
Sure. So essentially, the Minister of Industry, after consulting with the Minister of Public Safety in this bill, is given the discretion to stop a telecommunication service provider from providing a service to any person or require a provider to suspend service for any amount of time to anybody. So, in simpler terms, services can be cut off from anyone at any time if the minister thinks it's necessary to prevent a laundry list of threats that includes interference or manipulation or disruption of a network, but none of those terms are actually defined in the Act. So, for example, if a ransomware incident is correctly traced to an IP address, the person at that address could be cut off from the internet. But if the investigation is faulty and the ransomware incident is incorrectly traced, that misidentified person could also be cut off. And then because the minister can issue these orders in secret, if he chooses, it might not be allowable for the internet service provider to even tell the individual why they've been cut off, which obviously is going to make it very difficult for that person to dispute the charges and clear their name and get reconnected to the world.
Wow, and that has really, really serious implications if all of your service has been cut off and you have no idea why and you have no way of getting it reinstated. Rosa, anything you want to add to that concern?
Brenda raises some really great points. And what's really important here is the secrecy that shrouds this entire bill. So, our telecom providers are actually forbidden from adequately informing their customers if they have been cut off, why they have been cut off, what has forced them to do so. There's a real concern that these secret disconnection orders might impact people who have a smart device like a toaster or a television that has been co-opted through a cyber attack through no fault of their own, and they may see their internet cut off without any understanding of why that's happened and very little accountability if they choose to appeal that decision and try to find out more information about why their services have been disconnected.
Wow. So, Rosa, you've also raised concerns that Bill C-26 empowers the government to collect broad categories of information and about how that information can be used. So, what types of information are you talking about, and how would this be different from information that telecoms are already collecting? And why should we be worried? I mean, telecoms already have a lot of our information.
Right. I mean, that's a big concern. We're talking about the most intimate details of our life. We all know that we use our digital devices to conduct aspects of our lives, to keep in touch with loved ones, to, have video chats, to email, and then also for our essential services like our health documents, our finances, our education, information about our children and our children's identity. So the bill puts all of these things within the scope of Canada's spy agencies and their partner organizations around the world in ways that we've actually never seen before.
Wow.
So all that information we're talking about, your bank, your credit union, your telecom provider, your energy provider, all of that would fall under Bill C-26 and would be accountable to CSE, which is Canada's spy agency, which already operates with very little accountability.
Brenda, one of the things that you have pointed out is that the changes in Bill C-26 would authorize the use of secret evidence in court. So, can you explain how that proposal would work?
Sure. So there are provisions in the bill for a judicial review of a cybersecurity direction. So that's a kind of a safeguard and a bill which is very short of safeguards because it gives those who are accused recourse to challenge orders if they think that they're unreasonable or ungrounded. But the rules around those reviews allow secret evidence to be presented before the judge and hidden from the applicants and the applicants' lawyers. And then the judges are allowed to use that information that's not even provided to the applicant in a security sanitized summary form to help form their decisions. So this is a very national security way of doing things. But even in national security certificate cases under the Immigrant and Refugee Protection Act, we provide for an amicus, who is a special security cleared lawyer who is in on the evidence and acts in the interest of the accused. And while that's an incomplete remedy, at least we do have a court decision that says that it meets the requirements of a fair process, whereas C-26 doesn't meet that requirement. There's no nod to that process.
And certainly the government is aware of these procedures and guardrails that they could have worked into the legislation but didn't. We've got to go to commercial break, but we will be right back.